My name is Jamie McDonald. I'm an attorney with McDonald Law Offices. Our firm represents individuals throughout the entire state of Arizona in consumer bankruptcy cases. Today I'm going to give you an overview of the Chapter 7 process. A Chapter 7 is a liquidation bankruptcy in which you attempt to get rid of as many of your debts as you can and simply get a fresh start. A Chapter 7 requires a great deal of information. When you retain our office, we give you a questionnaire and a checklist of documents that we will need to properly prepare your schedules and statements for filing with the court. Some of the documents we will need, for example, will be pay stubs if you're working, proof of other income, retirement, Social Security, unemployment, and so on. We will need copies of your state and federal tax returns for the last 2 years, copies of your bank statements for each bank account you have. We will also need as much information as you can provide us regarding your creditors. Regarding your creditors, we are not only going to use the information that you provide, but we also at this firm obtain your 3 credit reports and import all 3 reports directly into the schedules that are filed with the court. One of the benefits of doing this is the company we use, CIN Legal Data Services, imports the creditors directly into your schedules that are filed with the court with the correct bankruptcy department address for each creditor. Prior to the filing of your case, you're going to need to obtain a credit briefing from an approved credit counseling agency. This is a very simple process. There are probably 50 different companies that are licensed by the government to provide this service. Most of the companies allow you to do it either online or on the phone. Some of them you can actually go into their office and do it as well. The process usually takes around 45 minutes. The agency will review your income, expenses, and creditor information, and then advise you what type of options you have. Once your case is filed, the court will appoint a trustee. That trustee has many roles. The trustee is going to review your schedules and statements that were filed with the court. The trustee will send you a letter, usually within 7 to 10 days of the filing of your case, requesting certain information for verification purposes. Much of the information will be information we already requested, so when you put our information together to provide to us, make a separate copy so you already have it available for the trustee. For example, the trustee will request the pay stubs, tax returns, bank statements. He or she may also request car titles. If you've been divorced in the last 3 years, they'll ask for a copy of your final divorce decree and so on. One of the roles of the trustee is to liquidate your non-exempt assets, meaning they're going to sell them and then provide a dividend to your creditors. In most Chapter 7 cases, however, individuals do not actually lose any assets. Most cases are considered non-exempt, no asset cases, meaning that you either have no assets that are non-exempt, meaning they're not protected by law, or the non-exempt assets that you have a nominal value, therefore they're going to provide such a meaningless distribution to your creditors, the trustee does not bother to liquidate them. Within about 30 to 45 days after your case is filed, you'll be required to attend a meeting of creditors. The meeting is very simple. One of our attorneys from our office will be in attendance at the meeting with you. The court schedules approximately 6 cases per half hour. When it is your turn, we will approach the table with the trustee. The first thing you do is hand the trustee your driver's license and Social Security card. After the trustee reviews your IDs, he or she hands them back to you, swears you in, asks you to take a seat, and then they ask you some very simple questions. At the conclusion of the questioning, the trustee will inquire whether any creditors are present. Most cases, probably 99% of the cases, creditors do not actually appear at this meeting. Therefore, the meeting itself usually takes 3 to 5 minutes. No later than 45 days from the date you've attended that meeting, you're required to take a second course, a financial management course. Most of my clients tell me they actually enjoy this course. This is a course where the credit counseling agency reviews household budgets with you. The course can be taken online, on the phone, or in person, and usually takes approximately 2 hours to complete. The company will email you, send you, or fax you a certificate with your name on it that you must provide to us so that we can file that with the court. If you will be reaffirming any debt, such as a vehicle loan, you'll be required to attend a reaffirmation hearing anywhere from 30 to 60 days following the date that you're meeting your creditors. The court typically enters your discharge, completing your case, somewhere between 61 and 100 days from the date that we've attended that meeting of creditors. Once the discharge is entered, the court is going to send you and all of your creditors a copy of the discharge notice. That will end the case for you. If you have any questions regarding any of this, please give us a call. You can reach us at 480-968-3100. Our appointments are always free, and we'll be happy to discuss your situation with you.